Hello, I'm attorney Dan Marr. I've been practicing law in the state of New Hampshire since 1988 and in the Commonwealth of Massachusetts since 1996. And during that period of time, I have addressed quite a bit of contract cases for business clients of mine. And I'm going to talk today in New Hampshire about some of the defenses that there can happen as to contracts and how you would respond to them if you were trying to enforce a contract. So I'm going to be covering a variety of. One of the first and foremost is hitting the merits of the case where the other side goes and says they did not breach, but you breached. They'll look at the context of the contract itself, and if they're saying that they don't have to pay you because they say that you didn't do what you were supposed to do, that would be one of the primary defenses that would be out there. And when you're factoring in that question, you want to look before you make any claims to the other side. You want to see whether or not you've complied with everything you're supposed to. They're not paying you and walking away from the contract. It has to be a material breach. If there's some technical breach of something, they say they don't have to pay you. There's problems. The courts generally don't like to overthrow the entire contract purely because there's some smaller process. But if, by way of example, if you're buying a piece of machinery and the machinery is delivered and it doesn't work, and the fix of that machinery is going to cost tens of thousands of dollars, that would be a likely evidence of a material breach, and you'd be able to have some opportunities to tell them to try to cure the breach under there's something called the Uniform Commercial Code. In New Hampshire, it's RSA 382A. And basically you go through those processes and you deal with that issue, but you usually talk to an attorney in regards to that if you thought that was going to be the defense. One of the other issues that they come up with is what's called statute of limitations. In New Hampshire, as in all states, there are provisions of when you can bring a claim against somebody. So if you know about a breach and you have a certain period of time that you haven't taken action on it, in New Hampshire it's generally 3 years, then you might be too late. And that comes about when you're in a situation, you get you maybe have a contract for services, you have a contract for goods, and you say that the other side hasn't done anything about it, but then you don't do anything on that for a while, and then you make a claim against the person, and you say, well, I'm just getting, maybe you're just getting to it because you have other things going on, but you're just getting to it and it's passed from when the breach is, it's past the 3 years, then you might be out of luck. Generally, when you have contracts like a lease or something, each one of the terms when they fail to pay rent, each one of those is a breach, and you deal with the 3 years from that time period. New Hampshire generally for statute of limitations does not favor extensions of statute of limitations. They don't like that for public policy purposes, so it's very tough to deal with that. So putting a provision in that says it's going to be an extended period of time, watch out for those provisions. Better if you're within the 3 years to sue within the 3-year time period. And I don't recommend continuing to negotiate when somebody's talking to you about it. Absent them actually saying, I acknowledge the debt and I acknowledge I have to pay it, outside of that reaffirmation of the debt there to extend the statute of limitations, you have a problem. If you're negotiating, you think you're negotiating in good faith, still file suit within the time period. Another issue that comes out is somebody saying, I didn't have the capacity to enter into this contract. There's an exception for a situation. If it's voluntary incapacity, like drunkenness, there's some law in regards to that. But generally, the incapacity issues are for, the person had dementia, or perhaps the capacity issue can be a different thing. Is the wrong person signed the contract. So if you're entering into a contract with somebody and you have one person sign it, then there's an issue of whether or not the person had the authority to sign for the other person. The question that comes about there is whether or not they had implied authority. So if I'm entering into a contract with you and I say, I tap the shoulder of my friend Buddy here, is one of the best managers I have. I couldn't do anything without him. And then I leave you to talk to Buddy about the contract, and Buddy goes and signs the contract. I've given an implied authority based upon what I've said about him, that he's my agent and he can deal with you in regards to this. That's the problem if you have somebody that you're questioning whether or not they have the authority to do the contract. Another issue is what's called impossibility, but it's very tough or commercial impracticability or impossibility. Just because it's going to cost you some money to do it, it's going to cost you a lot of money to do it. It may not be enough. We had a lot of those issues dealing with COVID. It's very tough to get out of a contract purely because it's going to be financially difficult to deal. So those are some of the major defenses that I've seen for contracts. There's also, if there's a comment about lack of consideration, you want to think about, do you have what's called promissory estoppel? If somebody made a promise to you and you detrimentally rely on that promise, and then they go, well, wait a minute, I didn't get any consideration out of this deal, any consideration at all, because it's not insufficient in consideration, is no consideration, so I should be bound by the contract. There's something called promissory estoppel that might bind them still because they said something and you detrimentally relied and you did something based upon their representations. You might have that. It's called promissory estoppel. Lastly, there's also concepts of quantum meruit, which is implied in fact contract. If there's an inference where it looks like there's a contract there, or unjust enrichment. You can't go and have that Kimlon person come by, you see them doing your yard, you know they're supposed to be doing your neighbor's yard, but you're thinking it's a good idea because you're getting free bug treatment for your property. There can be an unjust enrichment claim there. I'm Attorney Dan Meyer. I've been doing this for quite a few years. I'm happy to talk to you if the opportunity arises. I'm at 603-883-5501. You can also check out my weekly vlogs. I do them all. You just go onto our webpage of naturallawword.com, click to my bio, and then you can get to my YouTube channel, the weekly vlog all by topic. Look forward to working with you if the opportunity arises. Thank you.